We do relish the opportunity to present to different sectors. And as you can well imagine, the hotel and tourism sector being one of our most critical to the Jamaican economy, we do need to reach out and have dialogue with you. And so we thank you for coming on board with us and facilitating this forum for us to be able to speak to your membership. Now, just to explain, Ms. Thompson having gone through the legislation, and we know that it is a lot for persons to consume. The material will be shared so persons can have a look back subsequent. And of course, if questions arise, then they can reach out for clarification. Madam Ely had asked in terms of where can persons get assistance. So I'm going to start with just answering that question. As Ms. Thompson indicated, we do facilitate communication via our various online channels, and we will be going live with our website very soon. So that will be an additional avenue for persons to reach out to us. However, our info@oic.gov.jm email is very much up, running, and quite active. We have been fielding questions, concerns, recommendations, various communication from different stakeholders relating to the implementation of the act or its implications for their particular business or sector. And so we do welcome those. Let me just point out first and foremost that the transitional period, which we are approaching the end of now, was a period that was instituted in the law for the benefit, worded for the controllers, but as you know, in terms of setting up a new regime, it operates also in terms of providing for allowance for the regulatory authority as well. Now, I say that to say the act is new for all of us. We are now building this out for Jamaica. There are countries that are significantly ahead of us. I had a meeting recently. I was invited to speak with the commissioner from Estonia, and one of the things they pointed out was the decades for which they have actually been administering, data protection as a regulator in their country. And so we are now just getting our act to be fully implemented December 1. There's a lot that goes into having a regulatory regime operational. And so we had a 2-year transitional period within which data controllers were expected to get prepared for the full implementation of the act. During that 2 years, as you can imagine, being a newly created authority, a newly created office, we also had the responsibility to prepare ourselves to perform the full mandate as was articulated by Ms. Thompson in the presentation. Now, we're cognizant of the fact that controllers are not necessarily fully ready to be fully compliant come December 1. Some of your membership may have heard the broadcast that was done at the post-cabinet briefing by the Minister, the Honorable Dana Dixon-Morris. I believe it was the 24th or 25th of October, wherein she spoke to the implementation of the Act and how it is proposed to proceed. And essentially, that message contained 2 things. One is an understanding that come December 1, there's to be a phased implementation of the Act. So notwithstanding the end of the transitional period, we are appreciative of the fact that it will still take more time for persons to have everything in place and to be fully ready to comply with all the various provisions. And so the second part of that messaging was that the aim that we have is to take a collaborative approach towards compliance. We are looking to work with persons in terms of ensuring that they start the journey, proceed on the journey, and eventually over time get to the point where we can say, okay, you're fully compliant or you're mostly compliant, or at least have addressed the major issues in terms of the requirements for data privacy and protection. So as at December 1, just to allay some of the fears that persons, not just in this sector, but otherwise have had, is there going to be a sort of big stick mentality towards enforcement, where if you have not met every single requirement under the Act, you'll be persecuted. And I use that word rather than prosecuted because of the anxiety that a lot of persons feel. On December 1, the Act will be brought into full effect. It means that technically, from a legal perspective, yes, all the sections of the Act will be in place. Is it possible for there to be prosecution of offenses under the Act as at December 1? Yes. Will we be seeking to prosecute every single matter that comes to our attention? Not necessarily. So there is an amount of allowance and discretion and understanding, for want of a better word, in terms of what is required of data protection, of data controllers, in terms of protection, and to what extent they are in a position to meet those requirements. Now, again, I'd like to point out for persons that what is important, appreciating that while some persons might be of the view that 2 years was not sufficient time to prepare, appreciating that nonetheless there is an imperative to comply, not just locally, but because of international trends and where the world and the economy is moving. There is a need for essentially all countries to take the journey that we are taking in terms of implementing data protection legislation and enforcing it. And so to this end, persons have to realize that essentially you should have already started. So if you have not started that compliance journey in terms of putting yourself in a state of readiness to comply with the different requirements, then this is to say that you are not just late, but you are very late. Because in terms of phased implementation and in terms of going forward, if consideration is going to be given to the extent to which persons are compliant or not compliant, and what is forgivable or not forgivable, that sort of thing, then one of the things we're going to be looking at surely are questions of, for example, due diligence. What have you done? What steps have you taken? How far have you reached? So yes, we recognize that entities might not be 100% ready, but naturally, if it is that a situation arises, if there's a report made to us, if there is a breach or contravention, we're going to ask the questions of, was this foreseeable? Was this preventable? Were there mechanisms in place? Were there things that the organization put into effect to prevent that from happening? How effective were these things? So what you want to do is to place yourself in a position to be able to say, well, even if I were not 100% compliant, here is where I'm coming from, here is what I am doing, here is where I am going, and indicate an intention, at the very least, to comply with the legislation and steps taken pursuant to that intention. So that, I think, is a part of the main message that we want to get out there to organizations, just in terms of appreciating what December 1 means going forward. Now, for assistance, as I said, communication can always be sent to us. We do try to respond as quickly and as fully as possible to as many requests as we can, but also the point that was being made is we do also have our own constraints and limitations, both in terms of human and other resources. So if there's a flood of requests coming in, what you may find is that that's when you get to delays in responding. And so in that regard, we do recommend that persons, seek out, if they have the means and if it is possible, the assistance of external individuals. So while it is that as a new market, we might not have a large volume of privacy specialists and consultants that can assist, there are quite a number of persons already operating, and individuals are constantly entering into the space. Since the enactment of the legislation, we have seen a pop-up of various training institutions providing different courses, different types of certification in order to put persons in a position whether to assist themselves or to assist others in terms of data compliance. And so two avenues that entities can look to are, one, the existing specialist. And in that regard, we have tried to assist in some way. There is no requirement under our legislation for us to specifically certify any practitioner in the area, and we don't expressly recommend any particular person. However, having gotten numerous queries from controllers such as yourself saying, I don't know where to go, I don't know who to look to, where can I get the help? I don't have anyone with this skill in-house. And what we sought to do is to help to identify individuals and organizations that provide some type of service in the area or related to data protection for those controllers. And so if you write to us or if you visit our current page that we utilize, it is under the Ministry of Science, Energy and Technology, which is where the organization was first established. So there is a link, www.mset.gov.jm/OIC. And on that specific page, you'll see some of the information that we had previously posted as an organization, and it does include a listing of data protection service providers that can provide you with some guidance, with some assistance. We've kept it very general in terms of just identify who the persons are, their contact information, the type of service that they provide. So, for example, one of the points that persons need to be mindful of is when you talk about data protection, most persons tend to immediately think cybersecurity. It is connected, but it is not the same thing. So cybersecurity and security-related concerns are a part of the whole data protection framework, but they're only one aspect of it. So when you speak to data protection, you're really looking at three things. You're looking at the security of your information, yes, but you're also looking at the privacy element, which is a little different. And you're also looking at your overall privacy framework in terms of how you treat with the issues that arise on either side. So when you talk about privacy, you're looking at things like your confidentiality of information. You're looking at things related to maintaining the integrity of information, as well as its availability and accessibility to the necessary persons. Now, if you look at it like that, you'll recognize that you can have a significant investment in security. So you've invested, you have the firewalls and you have the malware and you've encrypted your data and you've done all these technical things to ensure that, okay, it is protected. But then you still find that somebody makes a complaint and you are in breach of the act. Why? Because those aspects in terms of the organizational and technical measures speak to meeting the requirements of a particular data protection standard. So when you look at the presentation that Ms. Thompson gave, you'll see where the Act provides for 8 data protection standards, and maintaining appropriate organizational and technical measures for the protection of personal data is only one. So what might happen is that you find that you end up in breach of another, because you can have an internal user. Anybody, it could be an administrative assistant, it could be one of the attendants or somebody who's working in the restaurant of your hotel or your Airbnb or whatever it is, and that person has unauthorized access to guest data by whatever means. It could be as simple as the client services manager got up to take a bathroom break. The cleaner came in, was cleaning the office. The computer is up, it is open. This person is curious, Jamaican words fast, starts looking into things. I guess walks in and catches them and makes a complaint. Notwithstanding that your system is perfectly safe, because there might be a password on there that could have been utilized. But if it wasn't, and due to whatever reason, somebody who should not access the information then what you have is a very secure system, but you have a privacy breach. So that's a very simple way of getting persons to appreciate that when you look at the Data Protection Act and when you look at your obligations, you have to be mindful of both components. The security requirement, yes, in terms of what you can do to secure your data and protect it from especially external attacks. I read recently where they said the tourism sector was the third most targeted sector in the world for cyber attacks. Hence the importance of ensuring that you do everything possible to protect your data. But outside of that, looking at those standards that speak to the maintenance of the privacy of the information, and in contemplating that, a lot of the standards are expressed in such a way as to ensure that the data subject is fully protected, not just in terms of the information, but in terms of the rights that they have. So, for example, when you speak about minimizing data, this is literally saying to you in a very basic way, if you don't need it, you shouldn't have it. And while it could be potentially useful somewhere down the road, if you don't need it now, then you need to revisit why are you keeping it. If it is that you require certain information for a particular purpose, then you keep it for that purpose. And once the purpose is served, you need to look at things like disposing of this information. Now you realize that those are not so much security concerns, but they are concerns in terms of data protection from the privacy perspective. And I did mention the third part in terms of governance, because if you're going to successfully and properly comply with this legislation, then the governance of your organization and certainly your data protection strategies is also going to be very key. I say to individuals usually when we do a sensitization that you need to look at data protection as everybody's business, and you need to look at it from a top-down approach. Now I say everybody's business because anybody can cause you to be non-compliant. And so while it is that we do the sensitization to make the owners, the managers, the decision makers aware of the obligation, we need to have them be mindful that this is an obligation that you can only meet if everybody is on board with you. So you understand the importance of data protection and you understand what liability can mean for your hotel, depending on the fines that are imposed, because depending on the size of your organization, some of these fines could technically kill a business. They go up to as far as $10 million in terms of a fixed amount. But then you're also looking at certain penalties that might be calculated as a percentage of your turnover. And it's not looking at just what you may have made locally. If you operate in multiple jurisdictions, it can look at your worldwide turnover. So it gets pretty costly in terms of the risk. And so for that reason, you want to ensure that just as much as you at the top understand those persons reporting to you and the persons reporting to them and the persons reporting further down, all the way up to your lowest level or lowest paid staff, has at least a basic understanding of the importance of data protection. So they know what to access, what not to access. They can help you in terms of identifying risk and remedying risk within the organization and essentially keep you out of trouble. But we also say that you should take a top-down approach to it because, as you know, it has to start somewhere. And what we need are the persons at the top to push this. The fact is, at the end of the day, the wonderful, most pleasant bartender might be as privacy conscious as possible within the hotel. But at the end of the day, what can they do to ensure that the hotel is compliant? Who is listening to them when they make a recommendation about the treatment of tourist information, tourist personal data? The investment, and I speak to investment because This is one of those areas where compliance comes at a cost. The investment decision is going to come from the top. So when you speak about all the different requirements of compliance, it's going to cost organizations. I'll give you an example. Ms. Thompson mentioned the requirement for certain categories of controllers to appoint a data protection officer. Now, you're either going to hire somebody in-house, have this person on staff, and pay them to perform that service for you, in which case you might be looking at salaries, you might be looking at pension, you might be looking at other allowances. And you have to have regard to the fact that industry standards recommendations are that this is not going to be one of your lower level staff. Your data protection officer is going to end up being one of the most important officers for your organization, not just because of the role, but because just the having of this officer and having a proper framework for complying with the act is something that's going to assist you in terms of your business competitiveness. As persons become more aware, and I listen to the ED say, we don't have a contentious nature naturally as Jamaicans. We really don't sue as much as some other jurisdictions. But then you're in a sector where the majority of the persons that you serve are coming from other jurisdictions. And some of these jurisdictions are very contentious. And so you have persons coming from countries where they are privacy conscious, they are privacy aware, their laws are old, and they have seen some of the decisions that have been coming out of other jurisdictions. And so they may be looking to see some of these same things here. Now, to that extent, you need to be ready. And to the extent that having a DPO can assist you, not just in terms of your own compliance, but as a show to your consumers, to your clients, that you are compliant, then this is something that's going to help to boost your business. And it's something that you can market to others to indicate that you are a progressive organization. You're not like every other tourist or every other Airbnb. No, it's going to cost you though, because even if you do not internalize this officer, if you take the approach of outsourcing it, so you contract somebody to provide the service, that again is going to come at a cost. We do not regulate that cost. We cannot tell data privacy or protection service providers how much to charge. And there is a fairly wide range in the market depending on who you select or what you ask this person to assist you with. Whether it is that you just want them to come into your organization, do an initial consultation, help you to set up your compliance mechanisms in place, and then leave you alone to carry it out and implement the different strategies. Or if this is somebody that you want to appoint as your DPO and have them on call to perform the different services as the need arises, the costs vary significantly. And in some cases, depending on the service and the provider, it does go into the millions. So I've heard persons speak about just in terms of getting ready for December 1, getting ready for registration, and the steps that they have needed to take in order to make their organizations ready, and spending anywhere upwards from 1.5 million to almost 10 million. And who knows? I'm not aware of all the cost expended by persons. There might be organizations that have perhaps spent even more. Now, note that a lot will turn on, as I said, not just who you choose and the services you want, but also to an extent, the size of the organization and how much is required to be put in place. But the fact of the matter is, insofar as there's a cost to compliance, both in terms of putting in necessary systems, in terms of you having to engage, whether internally or externally, a data protection officer, then of course you have to budget and plan for that cost. So you're planning in terms of what compliance is going to cost you. But one of our recommendations is also to plan in terms of what non-compliance could potentially cost you. because nobody really plans on a breach, but it happens. Worst case scenario, if it is that you are found liable and one of these penalties is imposed. This act was not passed to see businesses die. This act was not passed to prevent persons from operating. So certainly the intention is not for a single breach, however impactful, to put a business out of business. But then the only way it's not going to have a severe adverse effect on you is if some consideration has been given to how you treat with that. So I recommend that organizations, whether individually or collectively, begin to explore as to how they can plan for that expense, the liability that comes with contravening the legislation. In that regard, looking at prevention, there are certain mechanisms that I would just bring to persons' attention in terms of what you need to be looking at as you go forward. Some of you may have considered these things already. Others might be thinking about it for the first time. The important thing is that they are being considered and that you will be moving towards action in them. So we spoke about investing in security, and we spoke about planning for liability to ensure business continuity. But other things you need to think about, not just heading towards December 1, but going beyond, because compliance is a continuous requirement, are things like your complaints management system. Do you have one in place? Because this act not only gives data subjects, the persons whose personal information that you're dealing with, certain rights, but it also allows them essentially to make a complaint if they don't believe that you are treating with their rights properly or treating with their data properly. Now, what you don't want is for them to complain to us. What you want is to be in a position, if you get not just a access request from a data subject, you want to be in a position to respond to that. It shouldn't be that it is at the point when somebody calls your main line, the receptionist picks up. They want to know, let us start with a query. They want to know what personal data you are holding for them and how this data is being processed. And they go further to ask, well, what third parties is this data being disclosed to and in which jurisdiction? I am almost certain none of the persons answering the main line to your organizations would be in a position to answer that query. And that's fine. You don't necessarily expect your receptionist to be able to furnish that information. The question is, what is your receptionist going to do when they get that call? What is the procedure for treating with that kind of issue? Have you identified someone to say, who do you channel this to? How soon should this person respond? What should the format or content of that response be like? Have you put those things in place already? The same thing happens in relation to responding to breaches, because if it is that the tourist sector is the third most targeted, and I've seen where one survey said up to, I think it was over 50% of businesses operating in the entity have experienced some kind of breach. So if this is the case, and you now have a law that imposes certain obligations on you, then you need to already have a plan as to how are you going to treat with this. So again, how do you identify weaknesses that make you vulnerable to breaches? What preventative measures can you put in place? But as it relates to responsiveness, again, whose duty is it to bring this to the attention of management? What format is your breach report going to take? Most importantly, how are you going to respond and how quickly can you respond? Because we see where the act is now requiring data controllers if they have a breach or contravention, to communicate it to us as the regulator within 72 hours. You're talking about 3 days. That's the fairly easy part. You can send us a letter, you can send us an email. We are building into the website a breach report form that will allow you to make that submission online. So we're facilitating the ease of that communication. But on the other side, the same act is also requiring you to notify affected data subjects. So if you, let's take a large hotel who may have hundreds of thousands of guest records on file, because you're not just keeping for your current guests, you have been operating for say 10 years, you have a computer system, all your guest records are online. If you have a breach tomorrow and even 50% of those persons' information is compromised, how quickly can you reach that number of persons to make them aware? Because remember, a breach can have an impact external to your organization. This information is captured for a reason. And so the affected data subject remains vulnerable. You don't know what the perpetrator might be using this information for and what it could do to them. So you have a duty, a responsibility to let each and every person whose data was affected know that they are so affected. Do you have a mechanism in place that will effectively allow you in a very short space of time to communicate what you need to that larger number of people? Is the information that you have for these persons sufficiently current to ensure that when you attempt to reach out to them, it is effective? And you do. So these are the types of considerations that we are asking data controllers to look into, to have, to start actioning. We are looking at data protection as a culture. Don't just think about it as a requirement under an act, something else you need to do and check a box to show that you're functioning as you should. Look at it as a cultural change that needs to happen within the country, whereby individuals, whether they are subjects or their controllers, become privacy focused, where they recognize the value of personal information, and so they are mindful of how it can be used or misused. Now, in order to effect that change, just as we are communicating to you as controllers, making you aware of the requirements, your obligations, the rights of your data subjects, you also need to communicate it, not just to your internal users, but to externals as well. Because a lot of the services that you provide are dependent on your own engagement of, for example, third-party suppliers. A lot of the information that you capture is not just held and stored by you. It is used to further various purposes. And so you're passing this information to other third parties, persons who are processing the information in different ways on your behalf. So you now have an implied duty to ensure that these persons also know and understand the requirements of the Act, know and understand the requirements for compliance, and are taking steps to comply themselves. And this is an important point, because insofar as you engage third parties for anything, and it can be very simple. You ask somebody to come in and even say archive your records for you. That's considered a part of data processing. If you have a lot of paper records and from time to time you use a record disposal company to do shredding and burning or whatever, that's also a part of processing. If you are doing your market research and so you allow some company to access your information in order to provide you with some statistics on your guests and services that they like, things like that, these are all parts of data processing. Now, the thing about it that you have to be mindful of is, in other jurisdictions, there is express provision for the liability of data processors. So you engage a third party to do some aspect of your process for you. you pass personal information for them for that purpose, they are not complying with all the standards under the Act and they are in breach. In other jurisdictions, the primary focus is on them. That's where the breach lies. You hold them responsible. In our jurisdiction, as you look at the Act and what it requires of you, be very mindful that the obligations are imposed on you. The obligations in the Act are all worded to say, the data controller shall, the data controller may, the data controller is required to. So at the end of the day, the responsibility for compliance with all aspects of data protection, all aspects of processing personal data, really rests with you, even if you have outsourced some part of the process. So it's important for you to have that communication to the persons that you are dealing with so that they can help you to comply. If they're in breach, essentially, you're in breach. In a similar way as you need to communicate to the persons that are assisting you with any part of your process, you also need to communicate with your data subjects. So we're doing as much as we can in terms of educating the public as to what this Act provides, what rights do they have now, how they can go about exercising these rights. But the responsibility is not ours alone. You also have a responsibility to ensure that your data subjects know that they are protected and how they are protected. And so the practice of communicating a data privacy policy is strongly encouraged. In fact, at the very least, in terms of you seeking to comply and demonstrating that you're taking steps towards data compliance, you can look at implementing a privacy policy, adopting a privacy notice, something that communicates both inward and outward. You want to be telling your customers, your consumers, your persons visiting your property that, hey, this is how I treat with your personal information. This is who I share it with. These are the ways in which it is protected. And in the event that you have any issue with my treating of your personal data, this is how you can reach me to air and resolve those issues. So these are certain minimum steps that persons can take in terms of compliance. And compliance is important generally, but I just want to point out one example where it can become important in a very specific way. Once you are operating a business, we know capital is crucial. And we are in an economy where a lot of the times your capital is going to be based on loans, investments. Well, what we have seen is that we already have heard of financial institutions that are taking the requirement for compliance with the Data Protection Act very seriously. Most recently, I got a call from a colleague in law regarding advice he needed to provide to a client. And this was on the basis that the individual seeking a loan to fund their microfinance company was being asked to demonstrate that they are compliant with the DPA. So you see where not just us as the regulatory authority under this act, but other regulators under other act and other institutions on which you depend are now looking at data protection compliance as a requirement for certain services and as a requirement for dealing with you in certain ways. So this is just another of the incentives towards pushing you to compliance. I'd raise, and I know persons do have several questions, which I'm going to try to answer as best as possible. But the last thing I'd raise in terms of the comments that I would make are, we spoke about your compliance, your obligations to us and to others being your data subjects. But as it relates to your dealings with others and with each other, and again, it ties back to business continuity, but facilitating efficiency and expedience within the industry. One of the concerns that we are aware of, and it has been raised in other sectors, is how does data protection allow for, or to what extent does it prohibit data sharing or transfer of information? Now, we're very cognizant of the fact that information passes and needs to pass to facilitate doing business. When you take a booking, when there's an arrangement, whether it's with a travel agent or a tour operator, when you have an overflow and you have to pass guests perhaps to another facility to accommodate them on your behalf, there are necessary passings of information as between entities. And again, I have to emphasize that the Act was not passed to prevent or stop any business from occurring. The Act was passed to set certain limitations and boundaries as to how you can operate and to ensure that your interest in doing business is balanced against the interest of the person that you do business with. So can data be shared as between organizations? It has been done. It is being done. It is intended to continue being done. What is important is the how it is being done and ensuring that the arrangements that are in place are documented, they are in writing, and the provisions based on which it is being done are in keeping with the requirements of the Act for protecting the data. So the question is, what mechanisms do you have on place on your end? What mechanisms are in place on the other end? Are the parties equally liable, equally bound to maintain the obligations under the Act? And insofar as there might be special considerations for how a particular sector might operate, and whether it relates to sharing of data or other issues that touch and concern data privacy, then one of the things that we like to bring to the attention of groupings such as yourself is that the Act does provide for guidance to be issued in terms of how best to protect data or how best to carry out certain business having regard to data protection. Now, those can be initiated by our office, and we do have a duty to develop and disseminate those. However, the Act also provides for what are called self-initiated guidelines. And so this is something I bring to persons' attention because as we are building out, naturally, we have certain priorities, but also we are responsible for monitoring all sectors. And so the demand on us in terms of putting forward these guidance is great now and will continue to be great. So in terms of, say, expediting the delivery of guidance to a particular sector, it would assist if knowing what your own issues and concerns are and also being aware of what the existing practices are, what has worked and is working, then you are best poised to essentially articulate what it is that you require and what would work for you in terms of these arrangements. And so that can be a trigger to the development and issue of guidance. So we do promote organizations such as yourself, reaching out to your members, reaching out to other associations or other sectors that you might have to deal with, looking at what your specific needs and concerns might be and how these can be addressed. And then either sharing those concerns with us or insofar as there's existing guidance, perhaps from other jurisdictions or wherever that can direct as to how you treat with a particular matter, then certainly the OIC is open to and is permitted under the law to look at those guidance that are developed by a particular sector or a particular group of stakeholders, and then to try now to work with you to review it, finalize it, and make a submission for its approval in order for it to be issued. So I will wrap there in terms of just general comments. I know I touched on a lot of different things, and it's not exhaustive. There is a lot more that can be said in this area, but I'm conscious of the time as well as that there are specific questions that would have been raised that persons have or want an answer to. I'll try my best in terms of responding to those. What we're not able to give you a specific answer to at this time, then we'll note, or you can always forward to us by email subsequent through the JHTA, and we'll try to forward those answers to you as soon as possible.